This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about what happens when an insurer that pays a Subguard claim does not defraud the subcontractor who failed to comply with his contract. And when the subcontractor claims he was defrauded by the insurer, that subcontractor must prove fraud by presenting evidence of proximate cause, and the subcontractor's breach caused the insurer to pay under its Subguard contract. It cannot be fraud. In a case entitled US Framing International versus Continental Building Company and others, the United States Court of Appeal for the Sixth Circuit on April 7, 2025, resolved an insurance claim resulting from a claim of breach of contract by a subcontractor. Continental Building Company, a general contractor, entered into a subcontract with US Framing International for framing services on 2 student housing projects. After a disagreement arose between the parties, US Framing left the project and Continental filed an insurance claim on the premise that US Framing had breached the subcontract. US Framing then sued Continental and several of its officers, alleging that Continental had committed insurance fraud under Tennessee law. The district court granted Continental's motion to dismiss because US Framing failed to plead any injury directly caused by Continental's allegedly fraudulent insurance claim. Continental contracted with US Framing for framing work on 2 student housing projects, one in Knoxville, Tennessee, and the other in Ann Arbor, Michigan. US Framing began work on the projects in 2017, but things didn't go well. US Framing and Continental soon began fighting about delays on Knoxville project. Each party blamed the other, and in December of 2017, the parties amended the subcontract. They agreed to wipe the slate clean by abandoning all delay-related claims against one another. That didn't quite solve the things involved. The next month, the parties agreed that US Framing would leave the Knoxville project, and the parties executed another change order, which provided that US Framing would leave the job and Continental will make no more payments, and these actions will suffice to complete the contract between the 2 parties with no recourse to either party. In February of 2018, Continental informed US Framing it was terminating the subcontract because of US Framing's failure to commence and satisfactorily continue correction of its previously noticed subcontract defaults. Continental also stopped paying US Framing on the Ann Arbor project. Subguard insurance, which was purchased by the general contractor or subcontractor default insurance, is a risk mitigation tool for general contractors to control subcontractor default risk. It protects general contractors and upstream parties from subcontractors who default on contracts because they are unable to finish their work, are no longer in business, or perform work so poorly that it must be redone. Several weeks after conclusion of the contract, Continental told its Subguard insurer, Steadfast Insurance Company, that US Framing had defaulted on the Knoxville subcontracts. Continental submitted a claim under the policy for around $2.8 million, which it later amended to allege over $6 million in damages. Steadfast paid Continental more than $3.1 million on the claims. The dispute between US Framing and Continental gave rise to several lawsuits. US Framing first sued Continental in Michigan State Court in 2018, seeking the remainder that Continental allegedly owed on the Ann Arbor subcontract. Eventually, the parties agreed to arbitrate claims relating to both the Ann Arbor and Knoxville projects, and in May of 2024, the arbitrator made a final determination awarding US Framing more than $2.9 million. Second, in 2021, US Framing, a Continental and Tennessee state court, seeking a declaratory judgment that US Framing did not default on the Knoxville subcontractor, that Continental's losses did not arise out of any alleged default by US Framing, and that Continental made material misstatements and omissions in submitting its Subguard claim to Steadfast. After Continental removed the case to federal court, the district court dismissed the case, concluding that US Framing's claim was time-barred. US Framing sued Continental and 6 of its executives under a Tennessee statute banning fraudulent or unlawful insurance acts. US Framing alleged that Continental and its executives committed insurance fraud by making misrepresentations and omissions submitting the Subguard claim. The district court granted defendants' motion to dismiss. On the merits, the court found that US Framing did not plausibly allege that it suffered economic damage directly resulting from Continental's alleged insurance fraud. The court also concluded that US Framing cannot recover attorney's fees or related expenses, nor can it recover the statutory penalty. The Court of Appeals affirmed the district court's decision. In 2001, the Tennessee legislature passed an act prohibiting insurance fraud. 2 sections of the act set forth criminal and civil insurance fraud violations, respectively. Another section provides that any person injured in the person's business or property by reason of a violation may sue to recover for the injury from the fraudster. The court concluded that because the fund's injuries were purely contingent on harm to third parties, they were too remote and indirect as a matter of law to come within the doctrine of proximate cause. US Framing's claims therefore failed, even if US Framing is correct that in the insurance fraud context, direct means proximate. Tennessee law governing fraud claims holds that the contingent injuries, like the ones US Framing alleges here, are just too remote to satisfy proximate cause. In my opinion, accusing an insured and an insurer of fraud because the insurer paid a claim under a Subguard insurance contract or a subcontractor default insurance policy requires a finding of proximate cause by the insurer designed to harm the plaintiff. Lack of such evidence defeated the claim. It is difficult, if not impossible, to prove that an insurer acted fraudulently by paying a claim its policy required. This video was adapted from my blog, Selma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also gain access to the more than 5,050 blog postings. Please tell your friends and colleagues about the blog so that they too can subscribe. The blog and the videos are all free. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider subscribing for a very small fee to my Substack publications. Thank you for your attention.